to the government that governs. And the duty of assessing and determining that freedom has been exercised is placed on the Supreme Court. It has the first, the original and the final jurisdiction. So it has to ensure that the will of the people carries the day, so that the grumbling will continue in some quarters, but at the end of the day, the country will be saved from a lot of problems. We know what we went through in 2007, 2008, simply because there were perceptions that the courts are not doing their work rightly. But I think we have since redeemed ourselves, and the Supreme Court has done well in the decisions they have made, and we have put the country on where it should be. I think I should stop there for now. Thank you.
Thank you very much, CJ. You still owe me the robes, but we'll deal with that in the next round. My colleague, Justice Baraza, must have some questions for the Chief Justice. Justice Baraza, over to you.
Is this on? Oh. Can I be on? All right. Trying to get my questions. I'll be there right now. Chief Justice Martha Koome, have a combined questions for you. What role, in your view, does stare decisis principle play within the Kenyan judicial system? Another limb to your question, CJ, in your view, what is the essence of Article 163, subsection 7, subarticle 7 of the Constitution, which stipulates that the Supreme Court is not bound by its decision? And from your experience, has this provision been instrumental to the court? And if so, how? Quite a mouthful, CJ, but you are up to the task. Please.
Thank you. I don't know. Thank you. Thank you very much, Dr. Nancy Barasa, our first Deputy Chief Justice and Vice President of the Court. First, allow me to say I've been walking on the shoes of the giants before you, who set up the Supreme Court, who established the very foundations that we have been building on since the Supreme Court was established. And let me say, there are institutions, these gentlemen on my right and on my left, there are institutions that carry the independence of the judiciary, that carry the centrality of the people when it comes to access to justice, and I'm always referring to them. So the question that has been put to me about stare and decisis is one that really requires no answer. Looking at the congregation before me, it is just that we have entrenched it in our Constitution to reflect the commitment that we have under the rule of law that requires we stand by the decisions that have been made by the higher courts, and it requires the lower courts, within the judicial hierarchy to adhere to precedents, bypass decisions of the higher courts. The key role of stay and decisis is to ensure that there is consistency in our decisions. The doctrine, of course, requires the lower courts, like the magistrate courts, the High Court, and courts of equal status, including the Court of Appeal, to follow decisions made by the Supreme Court. This also, apart from consistency, also ensures there is uniformity in the interpretation of the laws. There is also predictability and legal certainty. And I dare say also public trust when it comes to the rule of law, by enabling the citizens, including the legal professionals, to reasonably anticipate outcomes based on established legal interpretations. The other day, I and Justice Renaura attended an event which was organized by the tribunals. We were trying to bring all the tribunals together. We have many tribunals that deal with administrative issues, and they are trying to operate from one building. And one of the chairpersons of the tribunal said, nowadays we dispose so many matters because when they come to us, we tell them, the Court of Appeal has said like this. Do you really want to continue with this argument? Don't you want to settle this matter? The High Court has said this. The Supreme Court has said this. And that really explains the importance of precedents and stare decisis, which brings also judicial efficiency and reduces case backlog. I think what we need to do as a country is build on that testimony which was given by the tribunal, that when the ground has already been established, the principles have already been established, then we do not have to re-engineer the matter again. We need to settle. And we have many, many forums of settling matters through court annexed mediation, negotiations, and engaging also in NDR. Stare decisis, Honorable Retired DCJ, also contributes to helping judges and judicial officers make reference to past decisions rather than, extensively re-examining the same legal questions and principles that have been determined. Now, you have asked me to comment on this principle that binds everybody except the Supreme Court. I think the framers of the Constitution were careful to let the Supreme Court have some flexibility and adaptability to societal changes. We are now celebrating 12 years. There are some complexities that are knocking on our doors that were not there when the past decisions were made. And to that extent, then the Supreme Court is given the leeway to depart from their own decisions. I also wish to emphasize that because I was in the Court of Appeal before I came to the Supreme Court, we also give leeway to distinguish cases, because Andre, do you find cases that are completely the same, because of the facts, and there are some other nuances in law that make it possible for us to depart from previous decisions, sometimes without even overturning the precedent, but just to draw the difference between the facts that are before the particular bench and what was decided previously. So that power of the Supreme Court to overturn its own past decisions is essential for justice, because, you know, everything is transient, and the various systems of our societies also keep evolving. We now have technological advancements and also shifts in constitutional landscape. This morning we had the executive urge another area opening the parameters of defining public interests, also to take into account national interests. So, you know, we keep on getting new challenges, and for us to be progressive, I think that is why the Apex Court, as the ultimate interpreter of the Constitution, was given this power, so that we can continuously promote progressive jurisprudence. But in all this, we should never lose the foundation that Chief Justice Mutunga established of people-centeredness, that whatever we do, it must be to respond to the aspirations of the people, to promote constitutionalism, not to take away anything out of it. Thank you very much.
Thank you very much, CJ Kome. My next question goes to CJ Mutunga. In your very, very learned view, has the role of the Supreme Court shifted over the years in response to Kenya's changing political and social landscape? And if so, how?
I think, Professor, you should get one of your PhD students to answer that question, because it's a great question, but I haven't thought through it, because I look at what is happening with our judiciary as an experience of turns and twists. Okay? But these turns and twists are toward, we have a vision of, what, the judiciary should be. I can give the example of the African traditional justice systems. The three of us are very passionate, about it, and that's one area you can basically say, has been pursued by each one of us, and it's a very important area in the sense that if in the case of Kenya, the majority of the people don't come to our courts. They are going to the elders, they are going to the pastors, they are going to all manner of people to solve their disputes. So if you're talking about access to justice, people send us justice. There is this aspect of it, African, justice system that we started, and now actually it's reached a very, very important area, in my view, where the integration is being called upon of the two systems, what we call the formal and the informal. I think actually the modern one is the one that should be called informal, because the formal one is the one that is anchored in the justice needs, you know, of the people. And the other point I've always made about African justice systems is that it will put an end to this call by politicians who elected you, okay? Because the judiciary is going to get a popular and public following because of the achieving access to justice, you know, to all. And I think that will be very, very important for the judiciary, because we will have people, when the courts are not being built, it's the people who actually will raise those issues, the people who fight for financial, you know, independence as well. I've attended a few of those meetings, and I've seen that spirit of people's, you know, involvement. And I think you can then say in the judiciary, you know, there are certain aspects that are still ongoing, the others that are almost complete. But in this country, I doubt whether you get anybody who says that, who envisions a judiciary that has collapsed. There is no Kenyan, you know, we are the only institution left standing, for heaven's sake. So I think there's that popular popular opportunity that I think the AJS and the whole issue of access to justice for social transformation, it's going to pay, you know, dividends, even political dividends for us. And I think it's also one area which, when you look at what the Nigerians are doing, the Ghanaians, South Sudan is very strong on that, you know, African justice systems. It's something that is going to be very Pan-African, you know, in terms of approach, and because that's our past. So that's what I can actually say. I leave you to get a student who is going to write a PhD on that issue.
A brilliant answer, CJ. I take your
yes.
Suggestion on it. May I hand over to Professor or Doctor?
Thank you. Thank you, Dr. Baraza. Judge Kome, I am sure this question, you will not refer me to a PhD student like Judge Mutunga. If I look at this room, CJ, I see Chief Justices and other justices from outside the country. I also see several other actors outside the judiciary. So I want to use that to discuss with you the place of collaborations and partnerships in the growth of the Supreme Court, but also the challenges that have brought and how you've navigated them. Because on the one instance, people say, you know, if you talk to these people, they will influence what you do. So if you look at your 12 years, to what extent has collaborations and partnerships with other judiciaries, but also other actors, civil society, the academia, and private sector, influenced the work and the jurisprudence of the Supreme Court, but also what challenges have arisen in the process and how have you dealt with them? Chief Justice Kome.
Thank you. I think the PhD student is myself. And I have the question already drawn, whether the judiciary or the Supreme Court has been able to settle the political question or the political doctrine. And I think the whole morning we were lamenting how, even now, no matter whatever decision we make to determine these political questions, they never hold because of the divisive nature of our politics, therefore judicializing politics. And I gave the example of all the presidential election disputes that were determined by the court. The solution was not the determination of the court. It is those protagonists who went and sat at a table and found a solution. The so-called handshake and the one now called broad-based government. And then you ask yourself, why didn't we start with the handshake? You know, why did you have to sweep all this to the court, to the Supreme Court, to expose the Supreme Court to ridicule, to attacks, to everything? Then you end up with a handshake. So what Chief Justice Mutunga is talking about is what we are talking about as the Africa Chief Justices. We've just come from a high-level forum where we were 16 Chief Justices attending a fellowship on alternative dispute resolution. And after going through 6 months of study, we confirm, Chief Justice Mutunga, that is actually Africa alternative dispute resolution. Because we, Africa, are the depositories of institutions of dispute resolution, which we trashed when we received this colonial legal system and tried to interpose it to our way of life. Therefore, that's why it never responded to our needs. And that's why Chief Justice was talking about a justice needs survey, which he did here in Kenya in, I think, 2017, which revealed that it's only 10% of Kenyans who can afford to access justice through the formal justice system. The other 70% will go to other forums, to the elders tribunals, elders council, chiefs' offices, religious groups, communities, and solve their problems there. So if we are chief justices in Africa, and this is replicated everywhere because we all gave our testimonies, are we chief justices of 10%? We are chief justices of our country. Therefore, we must look for solutions that respond to the needs of our people. And that's why we have embraced alternative dispute resolution in all its facets. We have embraced court annex mediation, negotiations. We have embraced pre-bargaining, and we are going to speak this language to the entire continent, because even after we finished our fellowship, I think there is another cohort that is going on. We will continue to speak together on collaboration so that we speak in one voice. We speak even to the African Union, because as you know, politicians meet, but judges or chief justices never meet to say what are our challenges in Africa. Our challenges is deprivation of budgetary allocation. You are expected to run a judiciary with empty coffers. So we are going to talk about the independence of the judiciary and how to make it a reality. There must be budgetary allocation to the judiciaries. So if we can have a solid voice as African judiciary, that every country should at least allocate a percentage of its budget to the judiciary. That is when you will know where is the heart and the soul of the nation. The heart and the soul of the nation belongs to where their interests are. Is their interest in the rule of law? Is their interest in defending the human rights and defending constitutionalism? So collaboration, Professor Ondote, is absolutely important. Let me also say, we in Kenya have benefited a great deal from jurisprudence within Africa. These days, our Supreme Court, where I sit, before we turn to UK, our colonial master or others, we first of all look at what has other African judiciaries said on this issue. What has South Africa said? What has Ghana said? What has Nigeria said? Before now we develop our own theory. So we must hang together as a continent. The way African Union politicians organize themselves, judiciaries, we need to organize ourselves and find our voice to defend the independence of the judiciary, the budgetary allocation for the judiciary, to see to it that we deliver judicial services to our people. Thank you very much.
Thank you very much, Chief Justice Martha Koome. Finally, as we end this round, CJ Maraga, I watched your video for this conference, reflecting on where the Supreme Court has come from, and then ending by saying this conference provides an opportunity for the Supreme Court to get advice as to what it can do better into the future. But you didn't share those thoughts. This is going to be an opportunity to share your thoughts about the future. As you look into the next decade, a decade where the Supreme Court, as we were told in the morning, is becoming a teenager, what advice would you give to your colleagues remaining here so that the next 13 years can build on the groundwork they have done, so they become a global icon, as the President told us today morning, and not an unruly teenager, as Senior Counsel Jan Mohammed told some of us who were with her on Friday? What did you tell the Supreme Court?
Thank you, Professor. Given the mandate that has been vested upon the Supreme Court, there are very high expectations, very high public expectations from the country about what the Supreme Court should do. My view is that the Supreme Court should continue doing what it has been doing for the last 12 years. You will recall, Professor Mutunga, that the issue of revenue, the division of revenue between the national and the county government started during your time. It continued even during my time. The National Assembly and the Senate could not agree as to who should divide the revenue until the Supreme Court came out decisively and said, look, this is a mandate that has been given to both of you. You must sit together, and if you don't agree, there are mechanisms of mediation that can be done and agree. And I think since we gave that judgment, that issue has not come to the courts again. What you see in the country is the amount the county governments are asking to be given as opposed to what they are getting. So the Supreme Court, with those kind of expectations, should continue to do that. One other thing, because of those expectations and very many matters of public interest that have come to the Supreme Court, the Supreme Court needs to continue reflecting on the impact of their decisions upon the people. Reflect and see how your decisions are going to affect the public, so that you don't just decide cases knowing that you are the court of last resort. Reflect as to how, of course, within the framework of the case that you are dealing with, but reflect about the impact your decisions are going to have on the public, the consumers of justice. The other thing is, as I said earlier, the judicial authority, the people of Kenya have given the judicial authority to the judiciary. The Supreme Court is the apex court in the judiciary that determines quite a number of issues that come before it. Take time and reflect on the matters that have come, as I have said, what impact they are going to have, so that you continue assisting the Kenyan people. Just Goma has talked about the started Decisis. Where you find it necessary, and I'm sure that is not anything to be told, where you find it necessary, depart from your previous judgments, even partly depart from the previous judgments, so that you carry along the people that we are serving. Another aspect, maybe that's my last point, is that the courts are quite misunderstood in this country. And more so even the Chief Justice, the Supreme Court. And yet, when you come with a decision, even before people read it, you are seeing in the social media and everywhere a lot of condemnations. I think use opportunities like this one, public opportunities like this one, and tell the public what the Supreme Court does. Quite a number of times, the public thinks that the Supreme Court, the only case they decide is the presidential petitions that come to them. And yet, the Supreme Court is deciding very, very many cases that come up. As you give judgments on some of these cases, and I'm happy the Supreme Court is already doing that, get summaries of your judgments. Get summaries of your judgments so that those people who condemn you even before they read the judgment, if a judgment is running to 150 pages, you don't expect anybody else, even lawyers, unless they are concerned with an issue like that, to go reading it carefully to understand what the Supreme Court has said. So those summaries that you give, don't just think about the press. Think about the public and communicate to them what you have said in the judgments. Lastly, as the custodian of the Constitution, at your level as the Supreme Court, you can stand up to the political establishment, unlike the other lower judges, the other lower courts. The Supreme Court should be there to stand up to the political establishment, and as I've said more than once, to tell everyone, including even the executive, that constitutional authority is constrained authority. You are the only ones who can tell every institution in this country to walk in its path. And that's the only way we can continue having the rule of law. Thank you very much.
Thank you very much, Chief Justice. Ladies and gentlemen, when we were given this task, you heard the Chief of Staff saying we finish at 1. It is 1:20. But a panel discussion would be incomplete without your inputs. So I'll be inviting my colleague, Judge Baraza, for a very brief plenary discussion. We'll take only 3 questions, which the panelists will respond to as they make their final remarks, because we need to finish by 1:30. Dr. Baraza.
Thank you very much. Ladies and gentlemen, I think the floor is open for your responses and questions to our very esteemed Chief Justices. A question, Dr. Cross, please the Chief Justice that I would want to respond to it.
Thank you very much, Judge. My name is Mudhomi Nkolu. My question is, which branch of the law 12 years down the line can the Supreme Court claim it has developed truly indigenous jurisprudence as required under Section 3, I believe, so that someone studying legal systems anywhere in the world can say, this is truly Kenyan, responding to truly Kenyan realities and situations. Number two, why is it that our Supreme Court usually writes unanimous decisions? We do not expect a bench of 7 judges to invariably write unanimous decisions and what some of my friends call concurring dissent.
Thank you very much. Dr. Mudhomi, did you want a specific Chief Justice to respond, or any of them? Okay. Can we have another one? The lady there, I can't see far. Our colleague from Kigali. Yes.
Thank you, Your Honors. My name is Isabel Karihangabo, Justice of the Supreme Court in Rwanda. My question goes to the current CJ. You've talked about the importance of the jurisprudence and how the judiciary, the African judiciary, needs to come together for an advocacy of it having a certain importance and in their day-to-day duties. My question is to know about the jurisprudence. You said that it is important that we as Africans learn to know jurisprudence of all countries. And I would want to know how do you think we should make sure that all case laws that have been adjudicated by African countries are accessible to all African countries so that we can develop African jurisprudence. Thank you, my honor.
Thank you very much. The gentleman. Yes. You, yes, yes, sir. Yes, yourself.
Thank you, Madam Facilitate Director. It was quite a pleasure to listen to the current...
It's from the Supreme Court, Papua New Guinea. Karibu sana. Thank you very much. Please.
Thank you. It was quite a pleasure, actually, to listen to the current Chief Justices and the 2 retired Chief Justices. And so quite a pleasure also to realize that they're quite aligned in terms of the vision and the very essence and role of the Supreme Court. I think Africa has a lot to learn from the Supreme Court of Kenya. When the political winds blow very viciously, they tend to stand firm. One question for Chief Justice, retired Chief Justice William Mutunga. I asked this question many years ago to Chief Justice, to Justice Sal of the South African Constitutional Court. You just mentioned that the Supreme Court is a political court. Are judges of the Supreme Court politicians in gowns, in flowing gowns? On account of absence of time, I think I must rest with that question. I had another for retired Chief Justice Maraga, but I will ask him on the sidelines. Thank you very much.
You can run through it and then we combine and answer.
I thought you omitted to, unless I missed it, to share some thinking around bringing back the wigs.
Thank you very much. I think we have had those responses. We can take one?
I think let's take the lady. Which is
The
just
lady,
fair
please.
as the last one.
Is that Betty?
Yes, yes it is.
Yes, please.
Yeah.
Go ahead.
Honorable Chief Justice and the Emeritus Chief Justices and the panelists, my question is directed sitting Chief Justice. Today's speech by His Excellency actually was, it spurred some thought process, you know, amongst issues which may be hanging out there, but they need to be located somewhere within the space of mediation, my thinking. And therefore my question, and I'm very happy that there was this 6 months course for the superior judges, the Chief Justices. So my question is, where, Madam CJ, do you find mediation sitting or dispute resolution within the political arena before matters escalate to the superior courts? Because they escalate, but then again, you can see for sure there's mediation that can be employed. So really directing the question is, whom do you think can run with empowering, maybe advocacy around mediation? Political parties may be having their dispute resolution mechanisms which need to be explored exhaustively before coming to the courts. But is there a way all this can be done in a way that even peace is enhanced within the country before finally matters come to the Superior Court, and again you see resulting again to, you know, a mediation table? What do you think we can do? Who are the players who can run with this? Madam Chief Justice, thank you very much.
Thank you very much. Chief Justice, did you catch anything for yourself to answer to?
Yeah.
Please go ahead.
Question whether judges are politicians in robes. My brother, that's what you asked? Yes. Indeed they are. Indeed they are. I come from a school that agrees totally with two scholars. One is Onyango Loka. He has a book out which the title is When Courts Do Politics. Okay? And then Professor Pedro Baxi, you know, who argues that as judiciaries we should realize that we're actually an institutional political actor, okay? And that we should deal with that issue that way. And when you look at transformative constitutions, right, the mandate of it, the fact that even as you develop jurisprudence, you're supposed to look at the history, you know, the sociology, the economics, the theology. You look at our constitution, the science, all that. So we're not staunch positivists. You know, the constitution doesn't allow us to be staunch positivists. It's supposed to look at these other, you know, disciplines, whether we bring in experts or we do whatever, right? And you know, that's it. And even at practical terms, my experience with the politicians is, as a Chief Justice, is that they don't listen to legal advice. So if you keep on telling them the Constitution does this and the other, they might not listen to you. But if you start giving them political advice, which every judge, I think, has. We all have political positions, right? They will listen. You know, they definitely listen. And I had experience with President Uhuru. Once he was seeking my legal advice, and I said, you go to the Attorney General. He's the one who is going to advise you. But I told him, but I can give you political advice. And he laughed, and he said, I'll be consulting you. He never consulted me. it's how we, we look at politics. And I think the doctrines that are coming out of America and everybody, I've seen a lot of people talk about it. They just look at that these transformative constitutions, whether it's Colombia, whether it's South Africa, whether it's India, and I should have mentioned, Professor Bhatia also has written on that particular, particular issue. So there is, I believe, judicial politics, and even what is decided has, has that aspect, So yes, the gowns are. The gowns we wear, we deal with political questions all the time. Our only limitation is our politics is anchored to the Constitution. We want to uphold the Constitution. And that's why when it comes to a presidential election, we basically deal with it knowing that we'll be seen to to be addressing that issue, and because the Constitution has told us to, to deal with it, we just have to deal with it.
Thank you very much.
But that debate continues. That's my view. I thought the three professors I've read have basically told me, drop this hypocrisy that, your staunch positivities and the law is a law is a law, it's not so in transformative constitutions. It's not.
Thank you very much, CJ. CJ Maraga, did you pick anything? Probably Dr. Muthomi's questions? Or?
Thank you. Thank you, Dr. Muthomi. Dr. Muthomi has asked one of the questions, why are judges writing joint judgments and concurring opinions? Sometimes until you are on that seat, Dr. Muthomi, you may not realize the pressure that the judges are working under. Ideally, I agree with you that judges, and especially in the Supreme Court, should write their own judgments, because even when you are concurring, your reasoning develops the law. We have seen quite a number of judgments where a judge has concurred, but he brings out a very innovative aspect, and it develops the law. What I know, as during the time I was in the Supreme Court, is that you sometimes found yourselves working under a lot of pressure, and some of the matters that you are dealing with are matters I would call run of the mill. They are not raising any innovative and new issues that you need to really write on. And some of them, you are not telling me that the Supreme Court has not written dissenting judgments. I wrote a few myself. I wrote a few even as Chief Justice. So it is all a question of what you are handling. And the pressure. Maybe you need to make recommendations so that the number of the Supreme Court judges can be increased, so that they have a little more time. Maintain the quorum of 5, but have them, I would say 9 of them, so that when you are not sitting, you have a lot more time to reflect and write on some other issues. Now, two of you have asked me about the what? About the week. Is it part of the Supreme Court jurisprudence? But anyway, if you look at it, even the gowns themselves, are they original to the African codes? It's an issue. As far as I'm concerned, that was not a very big issue. The fact that I wore a wig did not change my mindset, or did not change me in any way. But of course, people look at it differently, and each has his own opinion. Thank you.
Thank you very much, C.J. Maraka. Honorable C.J. Gome, please.
Yes, thank you. Thank you very much. I think Dr. Mugomi also asked a question whether there are any decisions of the Supreme Court that can distinguish ourselves and give us an identity as the Supreme Court. And Dr. Mugomi, being a teacher of law, I know you know those decisions. You know we have settled many, especially land issues, and you know land cuts across everywhere. You will find our decisions settling the thorny issue of customary trusts. You will find our decisions traversing in all areas of law, including commercial, and settling issues of NDR, and also issues of devolution. But I think I can get you a well-written out a presentation of the areas of law we have settled and where we are being quoted in other jurisdictions. My sister from Rwanda asked about how we can benefit from each other's jurisprudence. We, Africa, like it has been said, we are the depository of knowledge on how to resolve disputes that brings restoration in our society, that builds harmony, but we have no way of sharing. Recently, the Supreme Court of Kenya visited Rwanda to understudy your ICT, because at one point you are ahead of us with ICT, and to look at the Gashasha courts, how they were able to resolve a very difficult societal problem, political problem that had divided the country. And the connection between that resolution of disputes within Gashasha and how they were adopted by the formal courts. And for us, that was very important. So now, because we are moving to the world of technology, I think within ourselves, we should be able to have a portal that contains all our judgments in all the areas. And looking in this room, I see a lot of capacity, especially from our institutions like the NJJF, who can help us establish a portal where we can exchange these decisions, and we can be able to easily learn from each other. We from Kenya, we have the Kenya Law Reports, where you just type Kenya Law and all our decisions will pop up. But we can have a portal like that for all the Africa judiciaries. My sister Betty also wanted to know the place of mediation. You know it is embedded in the Constitution, the alternative justice system, which we are all required as the judiciary, as judges, judicial officers, and everybody to promote the alternative justice system. So mediation is critical. Mediation is the way out of the backlog of cases that we have. It is the way to resolve even the political questions that we are talking about that we have not been able to resolve with judicial pronouncements. If they had started with mediation, we would never have had the mandamanos that we have had in this country. We would never have had Gen Zs revolt, because they would have put everybody on the table and they found a solution that is acceptable to everybody. And at the end of it, they will shake hands. They will end up with an agreement, restorative justice, and harmony within the society. But we require many people to advocate for mediation and to tell Kenyans, let us go back to our foundation, which is NDR. Thank you very much.
Thank you very much, Chief Justices, for your very, very illuminating perspectives on our judiciary as we turn 12. And thank you very much, participants, for your questions. Due to time, if you have any more questions, please ask the good judge, the CJs over lunch. Thank you very much. Professor Odote?
No, thank you very much. Ladies and gentlemen, with that, we come to the end. Dr. Mudhomi, if you talk to Zakim yesterday did, I think, a summary of 165 judgments and rulings. You can try and analyze and see whether there's any that's indigenous jurisprudence. With that, colleagues, we come to the end of the session. Please join me in thanking the Chief Justices for an excellent presentation, demonstrating to us the benefit of leadership in terms of the Supreme Court. Let's then hand it over back to Washuka to take us from here. Thank you very much, and have a good afternoon.
What a phenomenal panel. I think we've picked amazing nuggets, first-hand experiences and reflections from the first 3 presidents of the Supreme Court of Kenya. Thank you very much, Your Ladyship, Your Lordships. Thank you, Professor, for moderating a phenomenal conversation. Allow me to make just a few announcements before we break for lunch. One is that you're welcome to lunch. And if you're wearing a white name tag, you will be served in the front tent if you're wearing a white name tag. If you're wearing a blue name tag, we have an amazing exclusive setup for you at the rear back of the tent. There are exhibition booths at the Supreme Court parking, soon to be home to the Supreme Court building. So please visit the exhibition center and engage with our exhibitors. There is also a prayer area designated for our delegates who profess Islam, and the protocol team will guide you to where that is. Let us agree that we can have lunch in 45 minutes so that by 2:30 we are back to push forward with 3 other phenomenal conversations. I look forward to see you then. If you're here, that means you have a front row seat to an exclusive conversation to demystify and reflect on really who and what the Supreme Court is. So see you in the afternoon. Enjoy lunch, and I am informed that we called a blessing to lunch, but just to call that blessing again, we can say the prayer together. For Lord to bless the food that we're about to partake and give us strength to continue with this engagement. Thank you and welcome to lunch. See you at 2:30.
Jazz.
Two. Hello? On the
Technologically doing so very well.
Yesterday I saw a post, a forum at which I believe Justice Mohammed Ibrahim will be speaking. I think we would like to see more of those. I think we would like to see more visibility of judges of the Supreme Court within an academic setting in which they speak about matters of public interest.
The judiciary badly requires financial autonomy. So it provided in Article 173 for a judiciary fund to be established to enable the judiciary to run its affairs.
Everyone around us, tell us what we've done right and what we've done wrong and what we can do better.
The judiciary is one of the three arms of government, not the third arm. There's need for the other two arms to consider the judiciary as part of the government.
We have not brought on board the general public. Courts will play their role, but theirs will be limited. To what extent can a Kenyan, for example, feel that they are part and parcel of what is happening?
As we celebrate these 12 years of this court, give us feedback. We shall introspect, and we can only make this court better and make our judiciary better for the sake of the great people of the Republic of Kenya.
Kenyans have been very supportive. As one of the levels of court in the judiciary, it has strengthened the independence, the judiciary. So Kenyans should know that the judiciary is there for them, the Supreme Court is there for them. Our doors are open, and with God's blessing and the support of all Kenyans, we would like to continue
Thank you.
Discharging our constitutional obligations.
Thank you very, very much. Welcome back, Honorable Chief Justices, Honorable Deputy Chief Justices, Honorable Justices, our distinguished delegates. Welcome back to the second session of this conference. This afternoon, we will be running 2 sessions. We seek an hour of your time to recoup the time that we lost in the morning. So we propose to take this session from 2:40 to 3:15. We will then have a 15-minute health break, and we will finish with a final session from 3:30 to 4:30. That way, we'll still finish before 5 o'clock. Allow me to welcome the session chair of this second session, Honorable Lady Justice Philomena Mbete Mwilu, the Deputy Chief Justice and Vice President of the Supreme Court of Kenya, to the stage, joined by Honorable Justice Gertrude Torkono, Chief Justice of the Republic of Ghana, Honorable Justice Ruzina Mzikamanda, Honorable Chief Justice of the Republic of Malawi, and Honorable Lady Justice Njoki Ndongo, Justice of the Supreme Court of Kenya. The bios of their ladyships and his lordship are in the booklet, they're in the program, so please look at those rich profiles as well. This panel will be demystifying apex courts with particular focus on traditions, practices, and experiences through the lens of our Supreme Court judge. My lady, it is now 2:40, and with your permission, we will end the session at 3:15 as guided. Thank you, my lady. Karibu.
Good afternoon, friends. You have heard what we are going to be discussing. And I'm going to speak the list, but so that we get full content, my teammates are the ones to mind time. We are supposed supposed to talk to the issue of demystifying apex courts. I don't know why the word demystify. And beyond the jurisdiction of apex courts, I wonder whether courts are not courts. But let's hear. And since charity begins at home, I invite our sister Judge Njoki to tell us this demystification of apex courts. Is the apex court not just a court? So what are some of those unique traditions and practices in our courts? What are they? How are they observed? Do they go towards demystifying the mandate of the court and the dispensation of justice? Those traditions and practices, have they evolved over time, or are we stuck in the past? To what extent are these practices indigenous to your courts? And this question could go to anyone, but let's start with Judge Njoki. Judge, please demystify your apex court.
Hello? Oh, thank you. Thank you very much, Deputy Chief Justice. The question was to what are the unique traditions and practices of the Kenyan Supreme Court. And I must say that there was a question that was asked earlier about why it is that the court has so many unanimous decisions. And one of the reasons, which is one of the traditions and practices we have in our courts, is that when we listen to matters, we go into conference, and our conferences are very thorough. Our conferences, we spend a lot of time in conferences. We go around the table listening to each judge. We can go round the table more than once, twice, until we have understood the points of law. We've understood each other. And by the time there is a concurring opinion or a dissenting opinion, it is because the discussion has been thorough and understood on the points of law that we are discussing. There are some courts that do not have such thorough conferences. But in the Supreme Court, I'm proud to say that we have them, and as a result, you will find that we have one judgment and not several. The sittings of the court also, and the way we sit when we're in physical court, we sit according to seniority. I trust that that might be also common with other courts. And we also have the tradition where the youngest judge of the court has the biggest burden in terms of research. When we conference, we start with them. As does the US Supreme Court, we use their model of conferencing. We also have a process by which we limit time. Similar to the US Supreme Court, parties before us have limited time within to make oral submissions. Parties have already filed their petitions. We have looked at their evidence. We have looked at their written submissions. We normally give parties between 10 and 20 minutes each. Unless we think that the questions before us are sufficiently complex to allow a party half an hour. But normally, we do not give more than that for a party to highlight their submissions. We have a timer in the courtroom. So the minute the time is up, your mic will go off, or you will be told that your time is up. It's possible for a party to ask for extension, but ordinarily we don't give it. This saves us a lot of time, giving us more time for conference than listening to oral submissions, and gives us more time to look at the files that are before us. Since COVID, the Supreme Court has engaged in virtual sessions. We very rarely nowadays do physical sittings. We will do a physical sitting where there's great public interest, like the presidential election petition, or we've had a number of cases where we know those cases need to be televised live. Those are the ones where we will sit physically. Otherwise, we have enjoyed very much sitting virtually, and actually sitting virtually has saved us a lot of time because for whatever reason, advocates tend to speak a lot in courtrooms, but in virtual court, they speak to the point, and that saves a lot of time. I must say one of the challenges that we've had in virtual sessions is etiquette of advocates. So we have practice directions that says advocates must be robed, the cameras must be on. Occasionally, we've had a situation where the Chief Justice will have to tell a party to switch off their camera. Somebody is in the bedroom or somewhere else. They should not be in the courtroom. So we are having those challenges of etiquette of the advocates. And finally, as you saw, we started this morning with the prayer of the Supreme Court. That is now a tradition of ours. We had a competition among our staff, and we now have a prayer which we say before each of our sessions and in meetings like this. And finally, we do robe. We have a ceremonial robe for ceremonies, and then we have a robe for court sessions. We are now in the process of getting robes for moot competitions. So I think, in a nutshell, that's a little bit about how we work.
Thank you very much, Judge. That's the Kenyan experience. My Lord Resin, Chief Justice Musikamanda, please tell us how it is done in Malawi, and in particular, please answer the next question. What strategies do you employ in dealing with time-sensitive and emotive and complex cases? I can almost guess what case I want you to answer, but I won't say what it is. My Lord Chief Justice.
Thank you very much. Thank you very much, Madam Moderator. Since I'm speaking for the first time, allow me to take a moment to congratulate the judiciary of Kenya and to congratulate the Supreme Court at 12. This is a highly momentous occasion, and it was quite an honor and a privilege for you to extend so graciously an invitation to us. So I think I must register that. I also sit in the Supreme Court, and what the Supreme Court Justice Ngugi has said, I would only say I concur, because that's exactly what we do in Malawi. We don't do it any differently on the traditions. Those are the traditions that we also follow. As a matter of fact, we do use Kenya as our learning place. So a number of my colleagues have come to Kenya to pick up a few lessons here and there, and then we get home and we implement some of those lessons. So it's quite an opportune moment that we could compare notes and say, well, we are doing similar things. Maybe to add a little bit on the traditions. Of course, we follow our mandate under the Constitution and under the laws. under the rules of court. Those really take priority. Also under practice directions. And of course the traditions that we inherited from our masters, the wearing of gowns and things, and wigs, those we do. We are on the Malawi Supreme Court, 11 of us, and we sit en banc. Before we resolved to sit en banc, we used to sit in panels of 3. And we realized that the different panels were actually coming up with sometimes conflicting decisions. And the jurisprudence was not developing as smoothly as it should have been done. And so we resolved to begin to sit en banc. Of course, sometimes 2 of the judges do not sit on the panel. At that time, they are working on their judgments and other things, while others are sitting. But in terms of preparation, we all prepare so that we can sit at any given time. The choice of preparation is not there. We all have to prepare. And then when it comes to sit, in our case, the judge president of the court is actually the deputy chief justice, unlike in Kenya. And it is the deputy chief justice and the registrar who really work on the natural judge choice, which then we use. And we also take control of the proceedings, so that the proceedings are judge-driven rather than lawyer-driven. And we, as a tradition, we publish our cause list quite early in the a session, which is a sitting which is about 3 months, so that lawyers get prepared and file all the necessary documents. And by the time we go to hearing, we'll have studied the case thoroughly as the justices. And perhaps when it comes to actual hearing, we may just wish that they clarify certain points in the arguments that they filed. And the judges will throw in a number of questions here and there to clarify that. Otherwise, again, we limit the time of advocacy to make sure that we don't spend too much time listening to irrelevant or displays by judges. Now, let me come to the specific question of how do you deal with sensitive, emotive, and complex cases. We know that as a judiciary, we don't operate in a vacuum. We operate in a society, and so we also follow events that are taking place. And we know we are in a position to say that this particular case requires quick attention, and it is a case that in the arrangement can easily jump the queue so that we can deal with it and dispose of it as quickly as possible so that society can move on. So we do isolate those cases that tend to be emotive, tend to be sensitive, and tend to be complex. But even in dealing with those cases, we confine ourselves to the dictates of the Constitution, which is what will guide us will be the law and the legally relevant facts, so that we don't get emotional about the emotive cases. We don't become part of the emotion, but we should still retain our neutrality and our impartiality, even in those circumstances. That's what we do in a brief statement. Thank you, Madam Chair.
Thank you, CJ. Time allowing, you will tell us whether anyone attempts to interfere with your piece. But until that time allows, this court, the Supreme Court of Kenya, now 12 years old, has benchmarked with lots of courts in Africa and beyond. And now I want to bring to us Judge Benjamin from Brazil, where this court visited last year in August. And we were shown how they do things there. The technology thing we are so proud of, we actually went there because they were famed as way ahead of us. But when we got there, we thought, well, we could teach them one or two things. But this is not about teaching them. This is about hearing what my Lord Judge Benjamin would share with us. My registrar, please.
I would like to begin thanking the Supreme Court of Kenya I would like to begin thanking the Supreme Court of Kenya for the invitation to participate in this important celebration. On the other hand, my apology for not being able to be there in person. I have known Kenya and my colleagues at the Supreme Court for many years. They are, all of them, friends, brothers and sisters. I have visited Kenya many times, and several members of the Supreme Court, led by my sister Martha Komi, were here not long ago. Let me also thank and salute my sister Philomena Mivilu, someone that I admire very much and is the moderator, the chair of our panel. In this panel, we have the challenge, and that's the title of it, the challenge to demystify apex courts, traditions, practice, and experience through the lenses of a Supreme Court judge. I think I should say to all of us, good luck to begin with, because Supreme Courts and apex courts are complex entities in themselves, by nature, so to speak. But if we pay attention to the changing role of courts and also the changing expectations of people in respect to courts, or the substance of the issues that are submitted to apex courts, then the question becomes very, very complex. I selected 3 points of the roadmap that I was, a roadmap of questions that I received. The first aspect has to do with the fact that apex courts are supposed to be the keepers of the status quo. That's the traditional role of us judges, especially our apex courts. But more recently, we have changed the way we see ourselves, and society has changed the way it sees us and our roles. Not just keepers of the status quo, because the status quo is ever changing, but keepers of the values and the new values, and also the expectations of society as a whole, and particularly the expectations of the most vulnerable groups. So here is the paradox. Keepers of the status quo, but a status quo that is always in flux, and all this requiring us to evolve evolve in the way we understand the status quo, but also in the way we organize ourselves, and even how we understand our role. Not so distant, not so close, but with a preoccupation that the big issues of society will not be stopped at the gates of the courts. The second point that I extract from this roadmap that I received is adaptation to what, and adaptation to, in respect to how. About the what, this varies from country to country, but on how to adapt, I think courts in the world are facing similar problems. First, they need to find ways to deliver justice and decide cases in a faster way. And within this box, we can put everything from alternative methods or techniques of dispute resolution all the way to changes in civil procedure or criminal procedure techniques, and the way we deal with a flood of cases. So the management of the court system itself, but also, and this is emerging very fast, and in some places, like in Brazil, it's already reality, a strong use of technology. The Kenyan colleagues know that, and they visited us, that my court is a no-paper court. So everything is digital. And nowadays, the whole system in Brazil, from the trial level deep in the Amazon, all the way to the state Supreme Courts, the Federal Court of Appeals, and to us. But we are going beyond that. And we need to go beyond that in light of the very fast development of artificial intelligence. But here, with not one grain, but several grains of salt. Because it's true that artificial intelligence is offering us a whole universe of opportunities, of doing things in a much speedy way, but it brings risks, all sorts of risks, to the way we manage the caseload and we deliver justice. So we have to explore, use, but at the same time we have to be careful, because the consequences might be devastating for us, but also to society as a whole. In my court, we are already using artificial intelligence, but still in areas that the risks are not so high. And the fact that we have everything digitalized helps, of course, the use of artificial intelligence. But again, we have to be careful and develop protocols. And in doing so, we cannot think that each court will do the same. We have to learn from each other. And there are experiences already in different parts of the world in respect to the use of artificial intelligence. Again, let's do it, or let's explore the possibility of doing, but keeping in mind the risks so we can protect ourselves and protect the public interest in bringing in artificial intelligence to the courtroom. Finally, the organizers asked us in the panel to share a memorable experience in our career as a justice at the Apex Court. I've been here in my court for 18 years, and I do remember very vividly something that happened, and I think that would be a memorable, or would qualify as a memorable experience. And it has to do with the language that we use, or the type of language that we use in our judgments. We were deliberating in a case that had to do with welfare benefits for an old couple, both of them in the late 70s, and they decided to be there in the audience. So a colleague read the judgment, and at the end, the husband and the wife stood up, they embraced each other, kisses, and one of them said, "We won." And us, the 5 justices in the panel, didn't know what to say, because in fact they had lost. But the way we phrase it, with a vocabulary and a narrative technique that we could easily understand, was completely misunderstood by those that had their rights, or their expected rights, being decided by us. So it is on this final note that we have also, in addition to the use of new methodologies, new technologies, even artificial intelligence, we have to keep in mind that what we write has to be minimally understood by those that have a stake in what we are doing. Again, congratulations to the Supreme Court of Kenya. Congratulations to the judges, all judges of Kenya, and to the people of Kenya for this anniversary. It's 12 years, but it seems much more than that as a consequence of everything that the judges of Kenya have done for the people of Kenya. Thank you again.
Thank you very much, Judge Benjamin, our friend and brother. Yeah, it's a lot of things we've done. We've had not 3, but 4 presidential election petitions, which is why my sister, Chief Justice Gertrude Tokono, please tell us. Being a judge can be an isolating and high pressure. How do you maintain balance in your personal and professional life? And being Chief Justice, and therefore the team leader of your colleagues on the court in Ghana, how do you maintain consistency in the court's decisions, whereas you practice in a rapidly changing legal and social environment? My lady.
Thank you very much for the invitation here. And like my brother on my right, let me congratulate Kenya for the leadership you consistently show. I recall being here in 2022 and thoroughly enjoying the conversation prior to the election petition, the level of preparation you made for that situation, probably because you had been in so many of them and knew how hot they were. So on the issue of maintaining balance in this high pressure position, I don't even know whether I maintain balance because I constantly feel pressured. But I can speak on the role of the Chief Justice. I see it as a place where I'm constantly flowing between 4 different roles, a quadrangle of roles. There is a role of the diplomat, where you interface with many institutions. For instance, this morning, you have hosted, and Her Ladyship was the chief host of the presidency. So you sit with a political group, you smile, and you go through and you write a speech and you listen to speeches. Then also you are an administrator over the entire judiciary. So all issues must be ever before your eyes. Which judge is going where, who is not feeling well, who can function in a particular court, who can best do this particular thing. So there's that administrative role. Then you are a leader who must cast a vision and compel the vision to be implemented. I recall reading through Chief Justice Kume's vision document when I hadn't become Chief Justice and nobody had told me I could become Chief Justice. But when the situation came, I remembered her document. And Your Ladyship, I cast a vision this year. In April, I actually presented it to my country, and I must say you mentored me from afar. So there is that leadership role where you have to articulate the needs of the institution and address those needs. And it's not just the institution, because it's a whole nation. You have to read through what access to justice means for different people, what has to be done. This morning we've had the conversations on increasing ADR because on a practical level, more matters are resolved outside of the courts. And so even though we have court-connected ADR, we also know the resolutions that go on in the chief's palaces, in the churches, etc., and how do we ensure that there is the input of legality. So what conversations you have with these communities, and because eventually if there's a problem with enforcement, it will land in the courts, and there are principles, there are decided principles on what the process should have entailed before the courts would recognize them as proper settlements. So that is also a duty of the courts and the Chief Justice ultimately. Then the fourth role is the role of a judge. You don't stop being a judge. You still preside over cases, and you still have to administer the Supreme Court. Because you are president of the court. And so I think that flowing through all these different roles, they managed to give me some work balance at work. But you know, we talk about work-life balance as if outside of work is life. But I love my family life, and I came with my husband. He's retired now, so he can afford to follow me. He can afford to follow me, but it's not always nice to go home. It's always nice. So I think that as a judge, it's good to invest in a home situation where you can actually feel relaxed. So there's that, and of course I love watching movies, I love fiction, I write all sorts of things, and so those different, I don't do too much sports now. I used to walk a lot, I don't, now I walk around my house because it's very funny walking outside with security. It takes the joy out of the exercise, so that is it. And then the second part of your question was maintaining consistency. Maintaining consistency. I think that we have the same circumstances as Kenya. Article 129 of our Constitution, our 1992 Constitution, allows the Supreme Court to be the only court that can move away from its earlier decisions and on the basis of what is right. The principle is what is right. And so, if you don't mind, I'll read it. The Supreme Court shall not be bound to follow the decisions of any other court, and that's 1292. And 1293 says the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to its right to do so. And all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. So that there is a principle, there is, of course, just like everything in law, there is a structure to departing even from your previous principles. And of course, if you do this, then there's a requirement to have a very strong overview of the existing jurisprudence. And because you know that as we articulate judgments, we are not doing it just for us or the people before us, but also for law schools, for the entire society, for academia, and directing the nation. And so consistency is maintained and departure is determined on established principles.
Before I can ask my panelists to give a parting shot, and assuming that these two beautiful girls will allow us a few minutes, I would ask us, the audience, to please bring those concerns to the three of us here. Anything you would like to raise on the topic, not outside this, demystifying apex courts, and on what we have already discussed. My lady, the CJ, someone please bring the mic here. Kindly identify your target.
Thank you, Deputy Justice of the Supreme Court of Kenya, and let me join my colleagues to congratulate the Court of Kenya in this celebration of its 12th anniversary as a high court. And let me also extend my appreciation for the nation extended the Supreme Court of the Republic of Liberia. Demystifying apex court. First of all, in my mind, we have to first find out if this is possible. And I am in total agreement with the gentleman from Brazil. Good luck to us. good luck to us. But I want to start my comments. I would like if Lady Justice Njoki, to answer this. We're talking about demystification of apex courts, and we know in this issue about demystification, it grows out of the people, particularly the general public, the non-legal group in our society, finding it impossible or confusing in understanding the Supreme Court or even the workings of any court within our jurisdiction. And the lady Chief Associate Justice said that, look, one of the things she pointed out was this virtual sitting and e-filing, etc. But my question then would be, who are the beneficiaries of this system, the e-filing, the virtual sitting? Because we have to remember that those of our citizenry who are in this state of mystification of apex courts are those who are non-legal. So even if you have all of these sophisticated mechanisms put in place, how do they benefit, in fact, this wider audience who only leave their cases in the hands of lawyers, and how do they, even if they begin to listen to these proceedings online, etc., with our legal language, with our legal terminologies, the cumbersome procedures, legal procedures, how effective can this tool be in, demystification of apex courts? That's my question to you, Justice Undugu. And my second concern goes to my sister, Chief Justice Tukonu. You answer a question about your, personal life as a Chief Justice in its whole mystery surrounding your position as, Chief Justice. And in my mind, being first among equals is one of the most daunting tasks I have faced. That is, and I'm sure we can all boldly confess to certain things, being on the Supreme Court bench. For me, that's the first concern of mine, being first among equals and the issues and concerns they raise as to you being Chief Justice, etc. Just for an example, quickly, I remember, because there are no lexicographers who have come to define the role of a Chief Justice and what he or she should wear, their demeanor, etc. So I remember being rebuked by some male members of the Supreme Court when I was appointed first Associate Justice. And I love this style of ankle bracelets. And they were trying to tell me, to dictate to me, that that cannot be on the Supreme Court. I say, if you give me a definition, okay, and a precedent talking about stare decisis, then I will look at it and I can answer you properly. But if you can't show me a precedent where wearing an ankle bracelet will determine from the knowledge and the wisdom I have, then don't come to me with that. I like these practical examples of defending positions in high places, especially being a woman. Thank you, Madam Moderator.
Well, thank you, Chief Justice. Yes, some of these things that are high pressure, for sitting on the court that you sit in. I'll take only one more on account of time. My brother there, please.
Yes, thank you. My name is Yauda Kwasari, Justice of the Supreme Court in Ghana. If I may, first of all, congratulate the host for 12 years of excellence journey into this experience that you have shared with us. And if I may be permitted, just two questions, very shortly. My first question respectfully will go to Honorable Lady Justice Njoki Indungu. Now, with the onset of social media, we've had situations where judges have been made the subject of serious public attacks and opprobrium. Just last week in Ghana, or about 2 weeks ago, we delivered a decision in Ghana on a constitutional matter. And the next day, our faces were splashed all over social media. And they threatened to publish our places of residence, the churches we go to, where the restaurants we visit, where we hang out. And my family was scared. We were absolutely scared. Now, I venture to think that in some of these situations, maybe the judiciary does not have an outlet where they can also have a mouthpiece for, as it were, telling the public or demystifying what the judiciary is all about. They see the judiciary in a mystic gap, and they really don't understand the basis for us reaching certain decisions. Some of them think that we arrive at unanimous decisions and they, as it were, impute all sorts of motives to us. So my question is, do you see the need for maybe having a public relations outlet for the judiciary in Kenya or maybe in any African country to tackle some of these attacks, to maybe come out and explain exactly or demystify what the judiciary is all about? If you see the need, whether it has been tested in Kenya, and 3, whether you can share with us some of your experiences out of such a testing. And my next question goes to Honorable Justice Izinkambanda from Rwanda. I was really struck by your... Malawi, I'm sorry, please forgive me. I was really struck by your statement that as part of your case management efforts, you publish cases maybe 3 months before the time scheduled for hearings.
Course list.
Yes.
The course list.
The course list, yes. You publish the course list, yes. I don't know whether you have a pool of judges from which you select your judges. And my question is, if you publish the course list, do you also publish the names of the judges who will sit on those cases? And if that is the case, wouldn't that give litigants the opportunity to maybe want to manipulate 3 months? If they have 3 whole months, won't it give them an opportunity to manipulate the judges before the date for hearing? I would want to know what your experiences are and whether you can shed some light on this aspect. Thank you very much.
Thank you, my Lord. Welcome to social media. If you only got it last week, we've had it here forever. In fact, last week I was said to have sat at midnight to bench. The truth is, I sat at 3:20 p.m. I don't know how that becomes midnight. First of all, I sleep at 9. But I was awake at midnight to do some benching of some matter here. And the order was received here. And we have a file movement register. And I took a copy of it and threw it to those who asked. But still they said I sat at midnight. Thank you very much and welcome to social media. Judge Njoki, I will ask you to answer that. Before you do, my lady Chief Justice Liberia, how as e-filing, virtual hearings helped. Judge Njoki wants me to get into the boiler room because it's part of my work. Now, in this country, we didn't do much of it until COVID. But when COVID happened, and you heard about the experience earlier, we realized very quickly that we couldn't close down the courts because of the nature of the work we do. And so initially, we started as an experiment. First of all, we thought COVID would be here for a week. It wasn't. But we thought during that 1 week, we could still keep justice accessible to the consumers. It took forever. And by the time we were out of COVID, we were so stuck on virtual hearings, it's very difficult now to tell us to hear matters physically every day. We do it, but on a need basis, on those unique cases where we must be heard. So who is benefiting? Are we reaching everybody? The answer is actually yes, including the pro se litigant, including those who have never been to school. In this building, for instance, we have a courtroom where litigants who are otherwise not technologically literate sit there and they are assisted by our people to log in and to follow the proceedings. The other day, the Supreme Court was hearing a matter concerning a litigant sitting in faraway Kericho. Kericho is several kilometers from here. And so what did we do? We told the litigant to go to the nearest court, sit there with our people, and they were assisted using judiciary resources to connect. And we had Mr. Mwai for hours because he was facilitated to hear us. Of course, there are challenges. Even some of our courts sometimes don't have power. You can't do this without power. We've tried to do this and the other, but we are majorly, I think, a success story. We couldn't go back ourselves, so we go enhancing our virtual capacity. It's increased the number of determinations we've made on the Supreme Court, despite the few challenges of you are in court and you know before the Supreme Court you should be robbed, but you're in bed instead, and you're not in bed alone. But these are the risks of being a judge and being one in apex courts. Let's start with Judge Njoki. Judge Njoki, what is this thing? Social media, what is this? Public relations outlet, what is this? How do we deal with it?
Thank you very much, DCJ. On the issue of social media, I think there is one thing to be said. If you are a member of a Supreme Court is not for the faint-hearted, and you must have a thick skin. If you don't, you must be in the wrong place. Social media are normally faceless individuals. They come with rapid fire of insults and allegations. Even if you were to hire a public relations officer, you cannot respond at the pace in which these faceless, fraudulent accusations are being made. So I think, for me, and since we started doing the presidential petition from 2013, I've just gotten used to it. I think it just comes with the job, unfortunately. I think, though, one of the things that we must realize is that because we are targeted as Apex Court members, we then tend to live a very solitary life. For me, that was a bit of a shock when I joined in 2011. I was not fully prepared. It's something I think when judges are orientated, they need to know that the transition into a completely solitary life where you live like a hermit is something that you'll do as a Supreme Court judge, especially if you're a woman. I don't know why society, particularly African society, lets the male judges off a little bit more, you know, like how you are being asked about your uncle. If a male judge dresses anyhow, there are no questions on them, but the questions are always on us. I think I'm more concerned sometimes when the vitriol and the venom against the court affects our families. I know in the presidential petitions, our children have suffered, and that is something which is of concern. I don't know, I guess we'll be preparing for the next one and know how we will deal with it. It's a very unfortunate set of events. But I just want to say that when the going gets tough, the tough get going.
Get going and get better in going. Thank you very much, Judge Njoki. Chief Justice Malawi, this case management you talked about, I could say one or two things about it, but my lord, those judges are only managing the cause list. They're not hearing cases before time. But could you please answer the concern, my lord, from Ghana Rest?
Thank you, Madam Moderator, and thank you for that question. Actually, the question reminded me of the common term, judge shopping, and it is the judges who are blamed for being shopped.
Yeah.
Those who actually do the shopping are not blamed, but it is the judges who are shopped who are being blamed. But anyway, I think the point has been made by the chair that the judges who are appointed, who were assigned the cases at the beginning, actually there for purposes of case management. So in our system, the rules of court provide, and this is not just for this is not for the Supreme Court now, this is for the High Court. They provide that once a case is registered, it is immediately assigned to a judge, so that all subsequent applications are taken to that judge. Then it comes to a time when there's a mediation, because we have court mediation, and the judge does the mediation. If the mediation is unsuccessful, at that point, the matter goes to another judge, a different judge. So that is how the rules manage that process. But we rely on the integrity of the judges, not to be bribed or to be shopped by any other. Thank you. I think as briefly as I can.
Thank you, my Lord Chief Justice. In closing remarks, my Lady Gertrude, case management and everything that we have discussed this evening in a word.
Thank you, Madam Moderator. It was interesting listening to my brother and sister because I could recognize virtually everything that was said. As some of the practices and traditions in Ghana, we conference a lot too. Unlike trial judges who have their own courtrooms, the Supreme Court, the appellate courts, we don't have our own courtrooms. So you're basically in your chambers, and then you come out there to sit as a group. We sit, our court sits as 5 people for appeals and for applications. When it's for review, we are 7. When it's a constitutional matter, we are 7. And if it's a review of a constitutional matter, then we are 9. So the number of people sitting on a matter depend on the nature of the case. We have a very, in fact, compared to many jurisdictions, we have a very expanded scope of cases. So I thought it was interesting. I think you had 600 cases or 400 cases. 600 cases. Well, this year I've had 400 cases. Yeah. So we have that many cases. So if all of us were to sit and bank, it couldn't be well managed. So we sit in panels, and then we manage with conferences. Being a leader of your peers is extremely pressuring, yes, especially if they were there before you came. But I think that the collegial nature of the bench helps, because we really do not function among the greater number of the community. We tend to be friends with each other. We tend to spend time with each other. So I guess that having had relations with everybody or built a good working relationship with everybody is easier. And the assignment of cases really, you didn't quibble before you became Chief Justice. So I know that judges accept it, that they have been assigned certain cases. So generally, I would say that case management is done by thorough conferencing and sometimes discussing drafts. And we also have the same rhetoric of why are you deciding unanimously. During the last election petition, they even called us the FC United, Unanimous FC, Unanimous FC, for having unanimous decisions on many occasions and then interlocutory applications. But really, I mean, if there's nothing to dissent from, why do you dissent? And so, and it's thoroughly, it's unnecessary work to try and write a decision on every matter. You would write your own opinion if you thought that there was something you wanted to emphasize and you wanted to bring to the attention of everyone. And so I think that I don't really know how one can demystify the Supreme Court, because I think that the law is not logical. I think that the law is not commonsensical. And to me, the best example is the fact that if you drove on the right in Kenya, you'd be breaking the law. But if you drove on the right in Ghana, you would be upholding the law. The law is what the people say it is. The law is, it is what it is. And so it's very difficult constantly, especially when the law is applied in the courtroom, where it's not just the facts that are being dealt with, but the weight of evidence and the rules of procedure, etc. So the demystification really ought to come from consistent engagement with stakeholders for them to appreciate the weight of the work that is done in the courtroom. I wish us luck.
Yes, we need it. Thank you very much, my lady. Thank you for being a wonderful audience. To Judge Benjamin, to my sister Gertrude, to Chief Justice Rezin, on behalf of the 7 of us on the Supreme Court, on behalf of the Kenyan judiciary, thank you very much for your facilitations at turning 13. We're actually 13 years old. It's just that we are modest, but we have just entered teenage. And I hope we can manage this properly. We are already preparing, God giving us life, for the 2027 presidential election petition. Here they come as a matter of fact. Thank you very much. Thank you.
Thank you. Thank you very much, my lady DCJ, for moderating a phenomenal conversation. And I'm sure that we all have picked up very, very interesting things. One of the most critical and reinforcing things that we continue to see is how empowering South-to-South cooperation is, because we get to learn that we have so many similarities and we face so many similar challenges. By the order of the Honorable Chief Justice, we will continue with the second panel and then have a break after this session towards the end of the day today, so that we can stay on course with time. So it gives me pleasure to invite Justice William Ouko, Judge of the Supreme Court, to moderate the next panel, session 3. And with him, I will invite Honorable Justice Professor Bethwell Ngake from the Residual Special Court of Sierra Leone, and Professor Kivutha Kibwana, Professor of Law at Daystar University and former Governor Makueni County. The panel will be discussing navigating judicial independence and accountability in the context of the Supreme Court's politically sensitive jurisdiction, and will go on until 4:30 when we will finish. Thank you very much.
Right, thank you very, very much. I think Leticia is being unfair. She told me before the Honorable DCJ took the podium that I will have 1 hour. She has, by fiat, reduced it, but I have powers more than her. I can review those orders. You have seen the topic in the program. What we are discussing today is going to be very easy ride, unlike the other heavy ones. And you can see I only have 2 panel members, very distinguished scholars, jurists. I don't expect to have any problems. It has been argued generally that it's a contradiction in terms to talk of judicial independence and accountability, that the two cannot coexist. You cannot have independence and claim accountability. And so what we are going to discuss today is how does the Supreme Court, or any court for that matter, balance these two principles. Mr. Justice Dingake, you were here in the morning and you heard everybody who spoke today talked of 2 terms, including the head of state, judicial independence, the interdependence between the various branches of government, and accountability. Because we are all not lawyers here, do you want to break it down for us, what these terms mean?
Thank you very much, Chair, for that question. I think the simplest way of speaking to independence of the judiciary or the independence of judges is basically to say that speaks to the freedom of judges to determine matters before them independently without any interference from any quarter, from the executive, from your pastor, from your family members, from your fellow judges. So a judge must have total freedom to determine a matter in a manner that, according to him or her, is what the facts and the law require. That is independence. Accountability is the other side of the coin to independence. It speaks to notions of integrity, that the judges have obligations to conduct themselves in a manner that is consistent with their judicial oath of office. Basically, accountability in simple terms speak to, among other things, critically curbing the bad behavior of judges. Now, judges are human beings. They are not gods or saints or whatever. They are also prone to misconduct. They can also be corrupt. And, but the duties that we have taken oath to perform require that we do so with absolute integrity. So that is the element of accountability. Now, you spoke about the two usually are in constant tension. And where does the tension arise? The tension arises because accountability almost puts some brakes, according to some, on the independence. Take, for example, the notion of one of the threats to independence of the judiciary is the appointment process. The manner in which judges are appointed. You find that some executives in Africa want to be in control of that process. And they not only in control of the appointment process, but discipline and removal of judges. So whoever has the power of discipline and the power to remove judges logically has the power to influence the judges. So that is where the tension is. But that tension is manageable because without accountability, then I do not think you can achieve what I call fair, effective justice.
Thank you, thank you, thank you. Thank you, my lord. Professor Kibwana, you just had some of my colleagues recount what they have gone through, what we continue to go through following some of the cases we hear. In your view of the 5 jurisdictional boundaries of the Supreme Court, which ones would you consider to be more politically sensitive, to be more emotive, and why?
Thank you very much, Honorable Justice. I had a problem trying to relate to this question of political sensitivity, because in my mind, I thought that when the Supreme Court is exercising its jurisdiction under the relevant articles of the Constitution, as well as the Supreme Court Act, in a democracy, if they do that, then you cannot accuse them of deciding in a manner to say that there is some political sensitivity, because they are using the law, they are using the facts, and therefore, strictly speaking, they really would not necessarily see any political sensitivity that they should respond to. But of course, there is a political question tied to justiciability, which are non-doctrines. So maybe the question becomes, what aspects of the Supreme Court's jurisdiction, what is this aspect that the executive, particularly the executive, is uncomfortable about, and to varying degrees? And I think, and this has been mentioned earlier, the original jurisdiction, when the Supreme Court is involved in presidential elections, time and again, every year, even now, I hear that there is a plan about 2027, how that will be approached. That is like the most problematic area. And unfortunately, the political class, and in my other life I used to belong there, we make the mess, or they made the mess. And after making the mess, you are invited to be arbiters. And when you arbitrate in a way not to please one of the factors, whether it is in 2013, 2027, 2022, then you are blamed. And there's recruitment of their supporters to blame the judiciary. In the first instance, it is not the judiciary which made the mistake. It's not the Supreme Court. It is because of what the political class has done. Maybe the other aspect is the issue concerning state of emergency, although we haven't had that in recent times. But potentially there can be conflict when there's challenge of the validity of the declaration, pursuant legislation and actions, the time period and all that. We saw in the situation of the military being invited to come to the streets during the Gen Z matters, we saw that there was discussion in that direction. And of course, when it comes to constitutional interpretation and application, where state organs are a party, again, they become uncomfortable, particularly when there are conservatory orders, when the judgment is not going in terms of what they want. And any appellate jurisdiction also, where the state seems to have an interest. And there are many situations, unfortunately, in our country, if I can be, quick, when there are questions of budget, questions of the finance bill, questions of CDF, vis-a-vis Parliament, even saying that it will shrink the budget of the judiciary, questions of the gender question, which has been lingering up to now, even after the Supreme Court was able, through the Chief Justice, to tell the President that Parliament should stand dissolved. That's still pending. We also, there was a lot of issues in the BBI constitutional judgment, devolution issues, and here, maybe I'll talk about it later a bit. This is where we thought, when I used to be in the county government system, we thought that the Supreme Court and the judiciary in totality really saved devolution to get it to the point where it is at. But there, the national level, was always introducing issues to say that these functions are not county functions, matters of revenue division, and also. And of course, the impeachment. And that's a very recent issue. But again, there, you can see that, people spotlighting the judiciary. And of course, it's not the judiciary which brought the impeachment matter to it. But you can see there is that, and so on and so forth. So there are many, unfortunately, there are many examples where that is not what should happen. And when other people make mess, if I can even use that language, then the Supreme Court is invited to clean the mess. And if it doesn't clean the mess the way in which those who have done some of those untoward things want it done, then the Supreme Court is blamed, the judiciary is blamed, and then you get people being mobilized to really say that the Supreme Court and the judiciary are not doing well.
Thank you.
Thank you, Prof. Thank you very much. My Lord, your wide experience. There are reports we read every day of threats by governments, particularly in Africa, to judicial independence. I just read, I think last week, a report by AJJF confirming that indeed in the continent of Africa, and particularly in this region, East Africa, that there are instances of threat to judicial independence, actual threats. In your view, what are the challenges that judiciaries in Africa face in terms of their independence?
Thank you very much. I have served in 3 jurisdictions in Africa. I've served in Botswana for over 10 years as a judge of the High Court and in the Labor Court. I have served in the Court of Appeal of Seychelles, and I now serve in the Pacific in the Supreme Court of Papua New Guinea. I sit with Isaac Lanaola in the Residual Special Court. I do not know whether we really sit or we are members of that court. So I have experiences from these jurisdictions that are actually quite interesting. First, from the constitutional architecture of those countries that obviously determine whether the judiciary is sufficiently anchored to be independent. So the constitutional framework of any given country is obviously very important. In one of these jurisdictions that I served in, I will not mention a single country by name. In one of these jurisdictions, for the time I served, no interference whatsoever from any politician on any matter, whether political in nature or your run-of-the-mill. Not from even a single litigant, not from my pastor, not from any of my family members. In one jurisdiction, I had a shock of my life. The interference that was persistent and continuous did not come from the executive or any litigant. It came from within the judiciary itself. And it becomes very difficult to navigate that situation. And in another third jurisdiction, from a litigant who was taking chances. But she was not persistent. So generally, however, in the African continent, the real threat or real challenges to judicial independence is this obsession by the executive to control the judiciary. And they think actually, some, that they can direct the judiciary how to decide, or they can intimidate the judiciary how to decide, especially in sensitive, politically sensitive matters. And the interference comes in all forms. It can be subtle, it can be direct, it can come through special emissaries. So we have a situation in Africa that is structural in nature, where some constitutions actually give the executive more power to appoint the judges of the Supreme Court, of the High Court, of the Court of Appeal, whatever name you give it. Let's give an example of where I come from. In Botswana, for instance, the Chief Justice is appointed by the President without the mechanism of the Judicial Service Commission. No public interviews. The President of the Court of Appeal, the Apex Court, it's appointed by the President, no Judicial Service Commission, no one recommends anything. The justices of the High Court and the Court of Appeal are appointed by the President on the recommendation of the Judicial Service Commission. The key provision of the Constitution says the judges of the High Court and the justices of the Court of Appeal, apparently there is a distinction between judges and justices. It says the judges of the High Court and the justices of the Court of Appeal shall be appointed by the President in accordance with the recommendations of the Judicial Service Commission. So the question has arisen and litigated up to the highest court, what is in accordance? Because although for the larger part of our post-independence period, the President just rubber-stamped, because at one of our judicial conferences, he said our Chief Justice told him clearly that your duty is to rubber-stamp. Because the Constitution says you shall appoint in accordance with the recommendations. So he said, I believe the Chief Justice completely, I just rubber-stamped. Then came the next president, he refused. He said, I can't rubber-stamp, I'm a president. And he refused to appoint the one that was recommended. So the matter went to court. And ultimately, the High Court held that, yes, how can you expect the president to rubber-stamp? So they said he's correct. So although that provision says in accordance, surely the president can't be a rubber stamp. The Court of Appeal said no, he is a rubber stamp. So as a result, that judge that was rejected by the president is now a judge of the High Court. When cornered, the president said, "What were your reasons in refusing that person who was recommended to be a judge?" The president says, "I can't disclose the security. There are security reasons I can't disclose," which was very unfair on the judge because it was implying all sorts of misconduct. So it is that control. So most of the Judicial Service Commission in Botswana, to dwell on it a bit, you find that is the Chief Justice who chairs it, the Attorney General is a member, the Chairperson of the Public Service Commission, a member of the public, all those are appointed by the President. And only one member is not appointed by the President, it's a representative of the Law Society. So the presidential appointees dominate the Judicial Service Commission. That is the control, if you like. I think in Kenya, Chief Justice, my sister here spoke about one of the challenges is actually adequate resources, finances. And you find that members of the executive can even use their control of the purse to punish for those decisions that they do not approve. Of course, they will not say we are punishing you because you delivered an unfavorable decision. They will say that scarcity of resources, there is a lot that we are dealing with, we have to distribute equitably, you are not the only ones. So, but that is a real challenge. In some jurisdictions, actually in Kenya, from a constitutional point of view, you are better off because I read your constitution that actually says your funding comes directly from the consolidated fund. In other jurisdictions, the judiciaries are departments in ministries. And so they are very dependent on the ministries, and actually the financial autonomy does not exist. The other challenges are corruption. You must stop me because the list is long.
Oh, that will be the last.
Okay. Corruption in the judiciary is a serious matter. It does undermine what we say we stand for. It does undermine our judicial independence, and is one of those things that the leadership of the judiciaries in Africa, whenever it rears its ugly head, they must come out very strongly against it and take immediate action, because it can erode the public confidence in the independence of the judiciary, and the judiciary as an organ that is supposed to conduct itself impeccably. Thank you. I'll stop there.
No, thank you,
I
my
left
Lord.
five
others.
Yes.
You can give us one that you consider very important for this audience.
I often say that court orders are not negotiable. When the court issues orders against the executive or against whosoever, those orders must be obeyed. So one of the things that undermines judicial independence is in jurisdictions where court orders are not obeyed. And there are so many ways of frustrating that. If it is an order that has implications for finance, they simply say the government is broke. There's nothing we can do. And in others, they simply delay. I think in Kenya you have experienced delays. Frustrating court orders, that undermines the independence of the judiciary.
Thank you very much,
Thank you.
Thank you very, very much. Prof, I'm sure you recall this day, beginning of this year, when Her Ladyship, the Honorable Chief Justice, flanked by her deputy, paid a visit to State House. There were members of the executive and the legislature in attendance, and there was a public outcry on why the CJ met the executive. And today, the head of state was here for this function of our celebration, and few things were said: collaboration, partnership between the three arms. Can there be a true constructive engagement between the judiciary and the other three arms of government? Can there be such an engagement that
does not compromise the independence of the judiciary?
I think maybe I can start by commenting on this aspect of, in the Kenyan situation, like when the judiciary made pronouncements on CDF, the legislators were very blunt. And they just said, we are going to minimize your budget. So it was not even subtle. So unfortunately, in this country, we have had issues where, particularly the legislature and maybe the executive in more subtle ways, or maybe not so subtle, will decide that one of the places to use to attack the judiciary is denial of funds, even when there is a judiciary fund. And that, of course, is not a positive thing. But I wanted to make the point that the executive in Kenya, in Africa, and maybe elsewhere, in the developing world, believe that they are first among equals in terms of the executive, the judiciary, the legislature. And even in Kenya, when we were making the constitution, we thought there was a fourth arm of government, constitutional commissions and independent officers. So that idea that the executive is ahead, it is the idea that is used to say we can also direct the other branches of government. But actually, it has to be accepted, according to the way the Constitution is framed, that the traditional three arms of government are equal. And none has more power than any other, because the Constitution just grants them different and separate powers. And I think that notion, that culture, if it was grasped and internalized, incarnated among the leadership, then some of these problems that we are having would be minimized. And for me, reading the Constitution, it is clear to me that the executive cannot do what the judiciary does. The executive cannot do what the legislature does, and the legislature, vice versa. So I think that's one critical aspect. Of course, I remember when the Chief Justice went to State House and accompanied, and now that the President, I'm told, has also been here, wasn't around then. You see, there is separation of powers. There is independence of the judiciary. There is separation of powers. But it doesn't mean that there isn't interdependence, because there are issues that must be done together with the leadership of, because that's the leadership of the entire country, respecting the lanes of each of the arms of government. And I think even when the Brazilian Chief Justice talked about the traditional role of status quo, that the judiciary protects like the status quo, maybe one can rephrase that to say that the arms of government, that leadership, is supposed together to secure the country. And when therefore, like now I would expect, the judiciary would go to the executive and tell them, it has taken too long to institute the Electoral Commission. Even some of the constitutional deadlines have been bypassed. We think that if there is an election petition going forward, there are going to be issues. Therefore, this is a matter to be attended to avoid a repeat of what happens each election season. So, I think even our populace has to accept and to understand that when these arms of government are in conversation because of that interdependency. That does not mean the judiciary has been bought. That does not mean, I don't know, what you do to the executive. Maybe you can't compromise it, I don't know. So I think it is the question which was raised earlier about how do you communicate to members of the public to understand, to the consumers of judicial services, to understand that the values that the judiciary will have, the vision it has, does not mean that when it sits with any branch, it will therefore sell out. And I think there is a lot of work to be done that, even the social media that was being talked about. I personally think that, the social media, because you can't stop it, as Justice of the Supreme Court, Njoki was saying, you will not stop them. At that feedback, in actual fact, like coming here, in a taxi, I was told that the judiciary is doing very badly. They have, when I said I'm coming to a meeting, they have been bought, all that kind of stuff. And I think one will listen to that sentiment. One will not say that that is the sentiment that describes what is happening. But it's important to listen to that sentiment and to know that there is public relations work, there is education work to be done, and so on. What would be unacceptable is if the executive calls the judiciary not in the public domain, and maybe just the Chief Justice goes alone, or two people go. It has to be a conversation which, again, is in a safe public space, and it is said this is what is being discussed, so that these notions of people are being compromised and so on, those notions are debunked. But there is no way that each arm of government can say we are going to work in a silo. That will not ultimately work, but the executive has to understand that the judiciary, the legislature, even the constitutional commissions and the independent offices, all those, according to the constitutional design, particularly the three branches are co-equal, and even with these independent offices, and therefore, to take a country forward, you respect that, and you work together, knowing ultimately you're exercising delegated authority at Article 1 of our Constitution from the people, and that's why that accountability to the people becomes important. And to conclude, to say that yes, it might appear as if there is a tension between accountability and independence, but the more you are accountable, the more it is possible to be truly independent, because if the executive tries to make you not independent, the people will come to support you, so that the people will say that we know, they are not corrupt, we know that they are accountable, and therefore they must be independent to deliver the justice that all of us requires, including justice when the executive needs justice.
Thank you so much, Prof, for that. I know Rose is looking at me. I have two more questions and I'm done. To my Lord, in these countries become very, very common whenever courts are hearing high-profile cases for judges to be profiled, to be labeled, to be threatened during, even after the decision is rendered. Given your background, and I believe even in your country, how can judges shield themselves as they deal with these sensitive cases against such accusations based on their ethnicity, based on their religion, based on their family? How can judges shield themselves from these accusations?
Thank you, my brother. It's tough to be a judge. It's very tough because you only owe allegiance to the Constitution. And When you deal with politically sensitive matters, it's even extremely difficult because whatever decision is given is viewed through a political lens, and usually a partisan political lens. The logic and the reasoning, whether the facts were sufficient and whether the correct law was applied, is usually lost. So what do the judges do? I think we must, of course, at all times, remain fiercely loyal to the Constitution, irrespective of whatever pressure, whatever accusations of being bought or being corrupt. But we also need to communicate much better, not in terms of our own judgment, and even in terms of public education outreach. The public there, the owners of the Constitution, we say in constitutional theory, need to be more informed in order to better appreciate the role of the Constitution. Because otherwise the reality out there now is there is a huge gap between public opinion, what I call public opinion, and informed public opinion. Those two sets are fields apart. And it is because sometimes, not always, we don't communicate effectively. We need to communicate. Judgments need to be simple without compromising the quality of legal reasoning. The consumers of this judgment, the people, must read and understand, especially as we always say as judges, especially in election petition, political sensitive cases, the losers must be able to understand your logic and why they lost more than the winners. It happens so often that in a judgment, the winner looks at the final order. If he has succeeded, that's all that matters. So we need to reach out by communicating much more effectively, public education. We also need the national education system, the schools, to actually be able to teach about the judiciary, its role, and how it functions. The other thing that we need to do, we must avoid any appearances of being biased. We must avoid, and those appearances of being biased, by the way, may come in so many forms. It may come in the posture, even in the manner in which you ask questions. The manner in which you ask questions may depict you not as being neutral and as already having taken a position. So I was reading the decision of one scholar critiquing the decision of the Supreme Court in the Gore versus Bush case, 2000 in the United States. And he had concentrated on the posture and the manner of questioning, and even said some of them were so arrogant. They thought they knew it all, the manner in which they were asking questions. So you need to avoid any appearances of bias. You must also have robust recusal practices. I mean, if it's not appropriate for you to sit, you should not sit. That is very important. So we must have those robust recusal and also very ethical, very strong ethical code of conduct. So that is how we can deal with issues, shield ourselves. And of course we must have, the judiciary must have a public relations office. It must have a spokesperson who explains these things. One of the judges this morning spoke about the need to, even to summarize some of these cases and explain the logic of a case. We need to do these things constantly and do outreach programs so that the people can understand. That is the only way of shielding ourselves. Thank you.
Thank you very much, my Lord, for that. Prof, you are here during the formation of Grand Coalition. And Grand Coalition instituted very many institutional reforms. One of its focus was the judiciary, which was described as corrupt, inept, totally weak. And the radical surgery came that sent more than 3/4 of judges. My question, Prof, are some of these measures the best measures to bring judicial accountability? Radical surgery that saw so many judges go home, the RAW vetting board that also so many judges and magistrates go home. The question is, are these the best ways to achieve institutional accountability?
I don't think so. I will answer that bluntly. Like the radical surgery happened because at that point the judiciary had been so contaminated, if I can say so, by virtue of its relationship with the executive, and even the nature like of appointments and even the judgments that support, for example, human rights abuses like detention without trial and all those kinds of things. And therefore, it was easy, if I can use that word, to use a method that was not constitutional, so to speak, because there were ways within the Constitution to remove errant judges. And what I don't know is its effect going forward in the judiciary, because that was probably a massive body blow to the judiciary, even if one was to say that the judiciary had been weakened through the one-party era or compromised. Because I think whatever methods that are used to ensure accountability in the judiciary, they must also follow the Constitution and they must follow laws. So you cannot improvise, so to speak. And I think in the task force that you chaired, there was discussion, there was ample discussion about whether there should have been a tribunal to process some of those judges, and I think Justice Waki was able to appeal, and he survived in that particular situation. Many people maybe did not want to do so, but I would myself emphasize what the judiciary does in-house. I think there is a huge opportunity there for the judiciary itself to make sure, through all those mechanisms, whether it is the ombudsman, whether it is even before we get to the role of the Judicial Service Commission itself, but internally, whether it's performance management, whether it's all those things that have been talked about, how you manage cases so that it is fair and all that kind of stuff. I think that is where the judiciary itself must really focus, so that self-regulation and it's explained to the citizen. This is what we are doing. You can complain here, and your complaints will be heard, and this is a very transparent. And when, of course, there are the issues of the Judicial Service Commission recommending when somebody has really done outrageous stuff for a tribunal and all that, so long as also it is also done fairly, because there are those who argue, the first tribunal of the Deputy Chief Justice, there are those who argue that perhaps it was kind of rushed, because there has to be that. It is a serious matter, because when you remove judges, you can also make the suggestion that the judiciary is not doing well. So you have to focus on cases that are very clear cases. And of course, when it comes to use of the criminal process, when it comes to the EACC, again, one has to be sure that some of those institutions are not also politically motivated to act, because if that again happens, then that's another way of trying to, suppress the judiciary, so to speak. But one thing that I would perhaps say in this forum is the strengthening of the internal mechanisms, and I think that's work that you're doing, work in progress, but that's very important that it is explained to the public so that they can know when, how, like what does all these courts do? How do I access them? If I have a problem, what do I do? And all that kind of stuff. I think in your report, if I can remember, you had very clearly said that is it DIAL, the Declaration of Income, Assets and Liabilities. You had said how even the judiciary itself must be able to make it clear, to even members of public. Because when you are being interviewed, you say these are my assets and all that. So when these declarations are made, why is it not possible to also say that, I got this much this year, from my salary, from what other, things I might be doing and all that. And I think that should be for all of the country. I don't think that this, the courts, they are working, because like I remember as governor, we would fill them and they would be taken somewhere and that was it. So unless again that law is made to work so that when those declarations are done, there is access to the public, and of course one could go on the more overall accountability in terms of mechanism, in terms of the Auditor General, the COB and all that kind of stuff, but that's another situation. But let me also, say, because I'm sure we are concluding, let me also say that because from just what I heard a little about trepidation going towards 2027 in terms of possible difficult cases, the judiciary must be wary of being too close to the political class. Because when I was part of that class, I could see how it can embrace the judiciary or some members of the judiciary, and after they are used, they can also be dumped. And so I think it is better the sovereign who delegates authority to you and to the executive and to all those people, it is better to cultivate that closeness with the populace, because those are the people who are going to protect you when guns come blazing. Because after the political people have made mistakes in the election, then they come and say you have made a wrong decision. So I think that's one thing that I would like to say, to ask to, and even some of those guys who are being very critical, if it was possible to find a way, I don't know whether it's arbitration or whatever it is, because as a governor, I saw the value that devolution gained from the judiciary. And if it wasn't the steadfastness of the judiciary in those many cases, and we have a list including the advisory opinion, including all those cases, devolution would be very weak today. And therefore, even those who criticize and one, has a right to criticize the judiciary or anybody, but you can also do it in a way to further lend credence to the fact that the judiciary is not good, and give ammunition to those who want to undermine it to actually do so. So I would say that I would myself think that it is good to call some of those people and tell them, okay, can there be a sit down and there is some discussion. I know that might not be an easy issue, but I think it's something worth considering.
Thank you so much, Prof. Thank you so much. Food for thought to the leadership, to all of us. Let's choose our friends wisely. Mwananchi should be our closest friend, and the political class will use you and dump you. The second food for thought is for us not to wait for another third radical surgery. We can be doing our things as we go along to deal with issues of integrity. I want to just allow 2 questions because of time to my members of the panel. Just 2 questions. Yes, my Lord, the Chief Justice. Yes. I don't know my voice. No, the mic is next.
Professor Kivuta Kibwana, I would like, my name is Ibrahim Juma. Professor Kivuta Kibwana, I think we worked some times back. And I'm glad to see you again after several lives. And I'm sure you have so much to tell us. Now, I quite agree with you, Professor Kibwana, that at times judiciary, we don't quite successfully explain what we are doing. I remember in Tanzania when the Warioba Commission report on corruption, it came out in 1996. All state organs were investigated, and the areas and loopholes of corruption were identified. Now, there were some entities which accepted that report as a working document and began to introspect themselves, to look inside and really try to address those problems. There are some which quite refused, just denied that there was any problem with the corruption. So what we did in our reforms, we have been trying to explain whatever we do, for instance, online filing of cases. There's a very powerful tool of fighting corruption because you are reducing personal contacts. I think we should find ways of explaining. By going 100% online, it means actually you are cutting away personal contacts. And also if we could negotiate with the executive that, like in Tanzania, judiciary has its own strategic plan and development plans, which it takes to the government for the government to fund, instead of forcing the Chief Justice to go and negotiate. In fact, we Chief Justices, when we meet the executive, it is not to negotiate cases. We negotiate some of the resources which are rightly for the judiciary, but somehow the resources does not come through. You are forced to go and see the head of state in order for him to oblige maybe the Minister of Finance to release what is maybe actually yours. And in our discussions, Chief Justice, we always ask ourselves, how do we get sufficient funding to enable us to be independent so that we do not have to go and talk to the executive, like Supreme Court building. I could see a lot of negotiations going on, the Chief Justice negotiating with the governor, head of state. Ideally, the funds should be there and the places should be there without the Chief Justice being forced to go there. So there are circumstances which force us to really have to go and talk to the head of state. And when an ordinary person sees the Chief Justice of Tanzania or Kenya talking with the head of state, you might think they are discussing court files. No, we are discussing about the welfare of judges, welfare of magistrates, and so forth. So thank you very much. I think your book on, together with Wanjala, on an anatomy of corruption, I think it is still relevant today. Thank you very much.
Thank you, my Lord. That is a very important perspective from Tanzania. Commissioner Ngutia?
Thank you, Judge, and thank you, the Justice Diganke and Professor Kibwana. My name is Jacqueline Ngutia. I am a member of the Judicial Service Commission, and hearing what you have to say, I think we are doing well as a country, save on the issue around financial independence, and we continue engaging the relevant agencies to ensure that we get there. Also allow me to congratulate the Supreme Court for this great milestone. We are looking forward to further and better achievements in the future. Justice Diganke, you mentioned that judges are human beings and therefore they're not prone to misconduct. In Kenya, we have the Judicial Code of Conduct, which highlights ways within which judges, judicial officers, and staff should operate. Again, we have the Supreme Court. It's pronounced itself on what the Judicial Service Commission or what the Chief Justice can do in terms of enforcing the Code of Conduct. And allow me to use the option that the Supreme Court, according to me, says it's only the nuclear option in the event of misconduct. The JSC's role is recommend for the establishment of a tribunal or nothing. So what does that mean when it comes to the issue of accountability? You can also mention to us your experiences from other jurisdictions on enforcing accountability that does not necessarily warrant the need to establish a tribunal. Issues around reprimand, warning, and not necessarily even at the JSC level, but even at the Chief Justice's level. And I agree with Professor Kibutha, we need to improve in-house to promote accountability. Thank you.
Thank you. Yes, I think the only question is to my lord.
Yes, in various jurisdictions in Africa, the approach is quite different. In Botswana, the discipline of judges in terms of the constitution is triggered once the Judicial Service Commission is seized of a complaint about any misconduct. Then they must then inform the president, who must establish a tribunal. And the findings of that tribunal, the recommendations are made to the president, and those recommendations are binding. There is not much detail around the issue of discipline and removal of judges. South Africa offers a totally different approach, where you find that there is various stages. You can be warned by the Chief Justice, there can be a reprimand, and there are those other acts of misconduct that then go to the tribunal. In PNG, where I sit, multifaceted approaches, the Constitution speaks about a leadership tribunal. So there is a leadership tribunal. That leadership tribunal presides over all acts of misconduct relating to PNG leaders. And in terms of the Constitution, leaders of PNG refers to the president, members of the cabinet, MPs, and judges. So if there is any misconduct, it goes to the leadership tribunal, and that leadership tribunal is made up of a judge appointed by the Chief Justice, a chief magistrate, and a member of the bar, I think. So the approaches are quite different. Thank you.
Thank you very much, my lord. Professor has one more thing to add in 1 minute.
I think something else that I didn't mention is the question of, peer, like among the judges, the Supreme Court, Court of Appeal, High Court, the magistracy, that question of peer-to-peer demand for accountability. I think that's an important, and I think there are mechanisms for how to achieve that. I think that's an important aspect of dealing with accountability. And I like the point that an interaction with the executive, maybe because the judiciary, for example, here has a judicial transformative framework which requires funding or even a strategic plan, and then that is not forthcoming through the channels as it should. And especially there's a judiciary fund and so on. And so I think that's why it's always important when there is that interaction for it to be clear what are the issues and for it to be in the open domain so that even an advance, that this is going to happen, so that these doubts that exist now, but the more we mature, then those doubts probably will not, exist. But I think that in situations where a legislature is gravitating more and more towards quote friendship with an executive, if we criticize the judiciary to death and we lose the judiciary, then we are in a dangerous spot. And I wish this is something that people can kind of appreciate, even as we criticize what should be criticized and what is not correct, if it's there are situations of corruption and all that, lack of accountability. But we must remember, you can lose all the three organs, and therefore you are in a wilderness.
Thank you very much. As I promised when we began, this was a very easy team, and as you can see, we've done exactly the time allocated, and they have delivered, although we had many more areas to discuss, but of course, because of time, there will be another anniversary, I believe. And so, I want to hand over to Rose, but I want you to help me appreciating my members for a great job. Thank you.
Thank you very much, my Lord Judge. Indeed, that has been a very, very interesting and rich conversation. Honorable Chief Justices, distinguished delegates, today we've delved into the Supreme Court's operating environment and, the complex ecosystem that the Supreme Court operates and has been for the last 12 years. Tomorrow, we delve into the nuts and bolts of jurisprudence, the Supreme Court's legacy, at 9 a.m. To close today's session is a 3-minute message of goodwill from the Right Honourable Chief Justice Sue Carr, Lady Chief Justice of England and Wales, and that will be the end of today's proceedings until 9 a.m. tomorrow. After this, we welcome you for tea and rich discussions in the evening. Technical team, let's have the message from the Lady Chief Justice.
Greetings from the Royal Courts of Justice in London. I am delighted to be joining you all today for this conference, which celebrates the 12th year of the Kenyan Supreme Court and the defence of your constitution over these years. I wish to extend my special thanks to my friend and colleague, Honourable Justice Martha Koome, Chief Justice and President of the Supreme Court of Kenya, for inviting me to deliver this short message. It was a real pleasure to welcome her here only last month, and I hope that she can see that I am treasuring the beautiful Maasai blanket that she so kindly gave me. The bonds between our respective jurisdictions are strong on both a personal and a professional level, not least through our joint membership of the Standing International Forum of Commercial Courts, SIFOC, and the Commonwealth Magistrates and Judges Association, CMJA, which will be held in the Gambia in 2025. I do hope to cross paths with many of you there. This gathering and your conference programme is a statement of the Kenyan judiciary's unwavering commitment to judicial independence and the protection of your constitution, both of which are the bedrock of a democratic, prosperous and functioning society. While all judiciaries across the world do, from time to time, face challenges to judicial independence, it remains in all our interests to continue to do all that we can to maintain it, to promote it, and to challenge any attempted breaches. It simply is not a principle that we can take for granted, and it is our collective responsibility to ensure that it remains intact. But how do we do this? One way is by joining together for conferences such as this, with a spirit of comity, collaboration, and by boosting morale amongst judges, progress can always be achieved. The judiciary can remain a cohesive and a committed unit. I believe that the well-being of judges, in part fortified through forming strong peer-to-peer bonds with colleagues, is vital for ensuring that we do a good job for those whom we serve. That is why we in England and Wales were pleased to be able to join the Kenyan judiciary in supporting iJump, the international judicial unique peer-to-peer mentoring programme. It has gone from strength to strength. This year, we now have 15 jurisdictions involved, with 128 judges participating. So I would therefore encourage each of you over the next few days to share your insights, to share your expertise, and to get involved in what looks like a packed conference agenda. By prioritising continuous learning and development, we can collectively enhance our jurisprudential contribution. I send you all my very best wishes for a successful conference. Thank you. Asante.
What a powerful message from the Right Lady Chief Justice Sukar there, sending that message from her chambers in London. Honourable Chief Justice, Honourable Chief Justices, Honourable Deputy Chief Justices, Your Ladyships, my lords, distinguished delegates, what a wonderful day it has been. We hope to see you all tomorrow. Enjoy the conversations that ensue from the rich discussions that we have had today. Asanteni. Welcome for a cup of tea. And tomorrow we start at 9 in the morning.
Wa Kenya, nchi yenye baraka. Kenya, nchi yenye baraka. Tumekomboa Kenya, taifa letu tukufu. Tumebadili mwendo, tutalinda katiba mpya. Anayependa Kenya ni yule mwenye kutenda haki kwa watu wote. Mtu mwenye kutenda haki. Na ukipenda Kenya ujitengane na mambo yenye kuvunja amani. Hatutaki matata Kenya. Wenye nchi Kenya kipenzi chetu, hatutaiacha milele daima. Wenye nchi Kenya kipenzi chetu, hatutaiacha milele daima. Kenya kipenzi chetu, nchi yenye upendo, hatutaacha Kenya daima na milele.